Hello, uh, I'm David Douglas. I'm the president of Effective Law Enforcement for All. We're a nonprofit organization whose mission is to help communities work collaboratively with their police departments to achieve a shared vision of law enforcement that is safe and effective for police and the communities they serve. We do that working locally with individual communities, but we're also trying to more broadly educate the public concerning safe and effective policing practices. As part of that mission, we have our Alifa Academy series, in which we look at hot topics, if you will, in policing and help the public understand those issues so that they can be knowledgeable and equal partners when it comes to interacting with their police departments. In this session, we're going to discuss use of force. The legal authorization to use force is one of the defining characteristics of law enforcement, and in many ways, the most iconic symbol of police. It has also, over the years, become one of the most controversial areas in police practices, with the rise, particularly, of cell phone videos, and now that the public has much more direct insight into how and when and why police use force. But police use of force is often not well understood by members of the public. And in some ways, in all fairness, not often well understood by some police officers. So our purpose today is to help illuminate this significant, controversial, and consequential issue by discussing some of the basic concepts regarding how police use of force is authorized and regulated both legally, but also by police department policy. After this discussion, we'll then have another discussion where we look at certain policies and how they operate to regulate police use of force. Now, to help us study this issue, I want to introduce two very distinguished guests who have years of experience with the legal, policy, and practical aspects of law enforcement generally and use of force specifically. First is Dr. Theron Bowman. Dr. Bowman has more than 30 years experience leading and managing some of the most complex and sophisticated police and public safety operations in the world. Dr. Bowman has led, managed, and participated in police practices oversight in multiple locations, including Albuquerque, New Mexico, Baltimore, Maryland, Battle Creek, Michigan, Chicago, Illinois, Cleveland, Ohio, Los Angeles County, California, Maricopa County, Arizona, Newark, New Jersey, New Orleans, Louisiana, and Seattle, Washington. Dr. Bowman is former chief of the Arlington, Texas Police Department and retired as assistant city administrator over public safety for Arlington. He has been recognized extensively for the work he has done throughout his career and has received a proclamation of achievement from both the Texas State Senate and the U.S. House of Representatives. The John Ben Shepherd Public Leadership Institute presented him with the Outstanding Local Leader Award, and the Police Executive Research Forum presented him with the Gary P. Hayes Award. Dr. Bowman earned his PhD in Urban and Public Administration from the University of Texas at Arlington and is a graduate of the Senior Management Institute for Police, the FBI National Academy, and the FBI National Executive Institute. Thank you for joining us, Dr. Bowman. Next, we have Rashida Ogletree-George. Ms. Ogletree-George has most recently, currently serves as a consultant to police agencies. She has most recently served as the managing director of the Policing Reform Campaign at the NAACP Legal Defense Fund. In this capacity, she oversaw the day-to-day work of the campaign, which utilizes public advocacy, litigation, community organizing, and communication strategies to advance unbiased and accountable policing at the national and local levels. Before joining the Legal Defense Fund, Ms. Ogletree-George was a special counsel in the Special Litigation Section of the Civil Rights Division of the U.S. Department of Justice. She helped lead the group conducting pattern and practice investigations of police departments. She also has held leadership roles in negotiating and enforcing settlement agreements with police departments across the country, including departments in Cleveland, Ohio, Newark, New Jersey, Meridian, Missouri. Meridian, Mississippi. She received the Assistant Attorney General's Distinguished Service Award in 2015 and 2016. Prior to joining the Civil Rights Division, she spent 5 years as staff attorney for the Special Litigation Division of the Public Defender Service for the District of Columbia. She graduated from Columbia University and received her JD from NYU School of Law. Thank you for joining us, Ms. Ogletree-George.
Thank you.
And the reason the two of you are such a great pair is because Dr. Bowman brings the policing side of it and you bring the civil rights side of it. And it will be a great discussion on how those two perspectives, I guess, interact. So let's just start with the basics. In the law enforcement context, when we say use of force, Dr. Bowman, what are we talking about when we talk about force?
Well, there's a whole range of actions that the police endeavor in that might be described as force. Typically, any application of physical effort to compel a person to comply with the officer's demand, with a legal demand, is a use of force. And again, that might be in some agencies just simply being present in uniform might be considered force, and all the way to the use of deadly force, using a firearm or another weapon that could inflict serious bodily injury or death. There's a whole range of those efforts to compel compliance with a lawful order.
And you talked about the uniform. That's sort of often referred to as command presence.
Yes, it is. And not everybody would agree that just the presence of an officer would amount to using force. But I would ask you, what's your reaction when you're driving along the freeway and the speed limit is 70 and you're sitting on 75 and you see a state trooper off to the side? Does your heart go up in your throat? Do you look down at your speedometer to see how fast you're driving? The answer is yes, you do. Why? Not because the officer threatened you, but just the mere presence of that police officer created a reaction, and that reaction in you more than likely caused you to check your speed and make sure that you're abiding by the law. So I think just mere command presence of an officer has an effect of bringing a person into compliance.
I love that example. And it occurs to me another one is if you're walking down the street and a police officer says, "Hey, you're probably more likely to stop than if just an ordinary person says, "Hey, you," because the uniform communicates something.
Yeah, to many people and most people, that I would agree that is absolutely the case.
And that uniform, in fact, is the symbol of a police officer's authority to use force, all the way up to deadly force. Is that fair?
Yeah, I think that's fair. Here in the United States and in many other countries as well, that police uniform is that symbol of neutrality, symbol of authority, to use force if necessary, to have a person abide by a lawful order, for a person to abide by the law. In any government where there is the rule of law, then a police force is in place to ensure compliance with the law, and that uniform is the symbol of that authority.
And when we talk about force, you're saying it starts from the lowest level of command presence all the way to deadly force, but there's many, many different levels and forms of force in between, physical force, tasers, all sorts of things, right? It's a wide range of conduct that constitutes force.
Right, right, right. And if I can just give a couple of examples of police officer levels of force, is what we typically refer to them as. Just telling a person that he or she is under arrest, grabbing them by the arm, walking them to the patrol car to put them in the car could be considered a use of force. Or if a person doesn't want to come along and the officer has to grab their arm or twist their arm or put their arms behind their back to handcuff them, that's using what we call hands-on, but it's real mild or minor force. But that too is considered a use of force. Sometimes an unwilling person may not want to comply, and the officer has to apply some type of pressure point control tactic or some other physical hold, or put the person in some type of physical restraint in order to move them along, in order to get them to follow the officer's command. That's a higher level of force than just merely walking them to the patrol car. An officer may be required to use a chemical irritant like OC spray or like mace if the person is not abiding by the police officer's orders, and the situation is serious enough where something like mace or an OC spray is warranted. That might be applied. You mentioned taser earlier. Taser is a form of a conducted energy weapon, and in certain instances, if the officer does not want to or does not have to use his or her hands, if they don't want to go hands-on, but instead want to apply a conducted energy weapon, a taser, they can often do that to gain compliance. And although for many people the use of a taser may in their minds be considered a really serious, a really major use of force, in some departments they consider the use of a taser even less force than a chemical irritant, or the use of a baton or an item that you can strike a person with to gain compliance. But yet the use of a taser is an available weapon. And then that goes all the way up to deadly force as well. And we know the use of a firearm, the use of something like a flashlight, if you're using it in a way that could cause serious bodily injury or death, and certainly if you're striking a person on the head, above the neck, that might be considered the use of deadly force. And so force goes up to deadly force by the use of a device or firearm or some other tool that's designed to inflict major bodily injury or even death.
So we're already getting a sense of why this is such a complex, challenging area, because we're talking about a wide range of applications or forms of force. There is a question when we're talking with the public about police use of force that surprises me. So I'm going to put it to you. Why do police use force? Why do they have to use force?
Well, that's a great question, and without being too philosophical, the father of modern policing actually is a guy, Sir Robert Peel, created the London Metropolitan Police in 1829. In designing the first modern police force, Sir Robert Peel said that the extent to which we, the police, can gain voluntary compliance lessens proportionately the need to use force. So we use force when people don't voluntarily comply with the law or voluntarily comply with police officer authority. And so the amount of force or the degree of force that's used will be proportionate to the resistance. that the police officer experiences during that encounter or that engagement with that particular individual. So the short of it is police officers use force because they have to. Why do they have to? Because members of the public don't voluntarily comply with the legal order, and police officers, even after attempting to de-escalate the situation, they're required to impart physical force in order to gain compliance. And so that's why they use force, and how much force they use depends upon the level of resistance.
Now, and I don't want to be naive, but they also use force because they're at risk. They are also targets, and they find themselves in life-threatening situations with some degree of frequency. Is that fair?
That's fair. What you find in most instances is the police officer finds himself or herself in a situation where they must react or respond either to the person's initiating actions or to an unknown situation where his or her life or safety, or the life or safety of another person, is threatened or in danger in some type of unknown status. And so that's typically when police officers are required to use force. Not usually is there a situation presented where the police officers will initiate force out of the clear blue, but it's most often dictated either by the actions of the person that they're interacting with or by the situation that the police officer is involved with. And most often it's a situation that he or she did not select, did not create, did not impose upon themselves.
So we've talked about what force is and how and why it's used. So Ms. Ogletree-George, let me now turn to you and the legal framework. We understand why police use force, but what authorizes them to use force? What is different about being a police officer than it is, for example, me, a non-police officer?
The laws vary from state to state, but in general, civilians can only use force to protect themselves from harm, or to protect someone else from harm, or perhaps to protect property. There are laws that allow a citizen to make a citizen's arrest, but that doesn't come with it the authority to use force in order to complete a citizen's arrest.
So what is the source of a police officer's authority to use force?
Generally, it comes from state and local law. State and local law sets the standard governing police conduct, including police use of force. Police are required to take an oath, essentially promising to uphold the law, to follow the Constitution, to follow the laws in the state where they reside or where they plan to serve. And before they take that oath, they're also required to go through pretty significant training, generally covering the various types of force, including restraint techniques, or the use of a taser, or the use of a firearm. And they're expected to follow the policies of the particular department that they're a part of. And so police are given pretty significant authority, the authority to take away someone's liberty through arrest or detaining someone. But along with that authority, there comes a higher standard that we expect from police officers. And that's part of the oath and the promise to follow those laws.
Now, you talked about state and local authority, but it's interesting you didn't mention the federal government. Why don't we have we have state and local police officers. Why don't we have federal police?
The federal government does not have general policing authority. There's not a single federal use of force policy that local police departments across the country are required to follow, and that local law enforcement officers have to follow. Any department across the country and any officer does have to follow the Constitution. The Constitution mandates under the Fourth Amendment that people cannot just be seized. It protects people from seizure, and that can mean a couple of things in the policing context. It means that a police officer can't just stop someone and arrest someone without following certain requirements that are set by the Fourth Amendment. It also means that police can't use force that is unreasonable because that's also prohibited by the Fourth Amendment. There are other constitutional protections that apply when we're talking about policing. For example, the First Amendment that allows people to observe and possibly record police officers while they're performing their duties. It may protect a person's right to protest. There's also the Fifth Amendment that protects the right to silence, and the Sixth Amendment right to counsel. There's a variety of amendments that come into play when you're dealing with police officers. At least historically, the 14th Amendment was intended to ensure that police services were equitable. And so all of that, those constitutional amendments set the floor, the minimum standards that apply to police officers across the country.
And flowing from the 14th Amendment, there's there's a federal statute that makes it a crime when a police officer deprives someone of a constitutional right, including their right to life or liberty, under color of state law, without authorization. Is that right? Oh, I think you inadvertently hit your mute button.
Yes, and in fact, the federal government is permitted to move forward with federal prosecutions of police officers if they are acting in their capacity as an officer or law enforcement officer. They're acting in their official capacity and they engage in excessive force. There is the possibility of a federal prosecution, but it's a high standard to meet for those federal prosecutions. Not only must a prosecutor prove that an officer used force that was unreasonable, a prosecutor would also have to prove that that an officer essentially wanted to use excessive force or intended to use excessive force and did it willingly and knowingly. And so it's a very hard standard to meet.
And when we think about policing and excessive force or police misconduct, we frequently think of the Department of Justice coming in. And so I think what you've laid out is that while state and local law sets the authorization for police, the Constitution is the protection to ensure that that authorization or the conduct of the police do not violate our constitutional rights. And it's the role of the Department of Justice to enforce and protect those rights. Is that fair?
Yes, that's fair. Absolutely. And the standard that is set, the constitutional standard comes from the case Graham v. Connor. It's a Fourth Amendment case that was decided in 1979, and it involved a Black man who was in the midst of a diabetic emergency. He was dealing with low blood sugar and wanted to get some juice to help his low blood sugar. He had a friend take him to a store. He ran in quickly, saw that there was a line and ran out and decided to go to a friend's house instead, another friend's house. An officer from the Charlotte Police Department saw this happen and thought it was suspicious and determined that Mr. Graham was trying to steal something from the store. He ultimately stopped Mr. Graham and his friend and detained Mr. Graham. Backup officers came and Mr. Graham was forced on the hood of a car, sustained numerous injuries, including a broken foot and an injured shoulder. But the court looked at what happened to Mr. Graham and ultimately determined a test that would be used going forward for all claims of excessive force, that allegations that there was a Fourth Amendment violation. The test that the Supreme Court came up with in that case was that that officers are allowed to use force if it's objectively reasonable under the circumstances. The court said there are a number of factors that an officer or that a court can consider in making that determination, but it includes the severity of the crime, whether the officer was facing a threat, and whether the person who force was used against was resisting or trying to evade arrest. Um, Ultimately, the court said that when we're assessing the reasonableness of force, we have to do it from the perspective of a reasonable officer on the scene. And the court also noted that you have to take into account that officers are making split second decisions, and that we can't make decisions that don't take that into account, these sort of tense situations that officers find themselves in.
And that decision has been criticized because essentially it makes it very hard to review a police officer's decision. I think for two reasons. One, it's if as you're saying, the test is at the moment the force is used, it's hard to put yourselves in the shoes of that officer, or easy for the officer to defend him or herself by saying, well, this is how it looked to me. But it's also problematic because it allows the police to set the standard for force. And I think what we're seeing, particularly with all the videos that are now out there, that people are saying, well, why do police get to decide? Or it doesn't look reasonable to me. Why is the view of the public less valuable or even less weight than the view of the police, who, after all, work for us?
Right, absolutely. The decision has been criticized because it purports to set an objective standard, but in practice, as we've seen Graham applied for many years since it was decided in 1979, judges and jurors often will defer to an officer's statement or belief about what he or she felt at that moment when the force was used, whether they felt a threat or a risk that justified the use of force. And what we've seen from research, the threat of force looks different depending on who the color of the person that the officer is encountering. There's bias in decision making that's been documented, that officers may be more likely to perceive a threat or a risk when confronting a person of color. And that ultimately may impact a decision to use force. There's been research showing that a mistake about whether there was a firearm or a cell phone, that mistake is more likely to happen when an officer is confronting a person of color. And so that's one of the criticisms of Graham, is that it bakes in some of that bias that may come in to decision making. And it also does focus on that exact moment when the force was used, and may not pay enough attention to all of the decisions that occurred before that final moment, tactical choices, an officer's decisions that have the potential to make force more necessary. And so some of the criticism is that we need to have a broader view of what led to the use of force instead of focusing on that exact moment.
And you've talked about the studies that show that police are quicker to shoot um, when the person the target is a black or brown person. And I think everyone's seen those scenarios where cops train and an image pops up and they have to make a split-second decision, and we're training. And those studies show that when it's a black or brown person that pops up, officers are quicker to fire. And I should add, it's not really because they're racist, but we really know a lot about implicit bias, and that we're all conditioned to associate black and brown people with danger, with negative values. And so it's a trigger, if not trained and addressed. There's a real risk there, uniquely to black and brown people.
Absolutely.
And by focusing sort of at the last moment, as you were alluding to, it doesn't encourage or require police to step back and make sure they've done everything they need to do to reduce the likelihood that they have to use force. And that leads to a saying in law enforcement that I'm going to ask Dr. Bowman about, lawful but awful. What does that saying describe?
I think that that terminology probably became prominent just a few years ago after the Police Executive Research Forum looked at a number of uses of force across the country. Many of them resulted in civil unrest. Some resulted in riots and civil disobedience. And the indications were that there was great community dissatisfaction regarding the police decision to use force. And in many of those instances, as Ms. Ogletree-George just indicated, the police were legally authorized to use force based on that last decision to use force, when not weighing the prelude to the force. What Perf found and what other researchers have found, in many cases, officers created that moment of jeopardy themselves. That there were opportunities to de-escalate, there were opportunities to make other decisions, there were opportunities to create more time to slow down the situation and scenario, to take cover, to use the advantages of concealment to slow the whole situation down, to allow other choices and other alternatives to take hold. And so when these situations have evolved into a lawful but awful situations, we looked at the moment when deadly force was actually used, and in that moment, it was probably authorized, but it's been highly questioned if that moment was even necessary, if that moment could have been avoided, and if in fact that moment had been avoided. In many cases, it probably could have been and should have been that awful outcome where somebody was seriously injured or killed should have never resulted. The force itself was lawful, but the outcome was awful.
And that's really what is fueling the public outrage. That notion that when we see these videos, like, you can tell in too many of them that there's just no reason for deadly force to have been used.
Well, there certainly appears to be, in most cases, alternatives to using deadly force. Now, I can't say that there was no reason, because one, you mentioned earlier, implicit bias. And implicit biases affect us all, even when we don't consciously understand that we're selecting a target because of the race of the person, or we're selecting it because we believe that that person meets the profile of a symbolic assailant, when in our mind and in our training, even the symbolic assailant has looked like a person of a certain color. So could have been avoidable had the officer been more sensitive to implicit biases, had been more sensitized with racial differences, had received more training on how to involve successfully in a crisis, how to intervene in a mental health related crisis. So there are many alternatives that might have changed the outcome had other choices been made, and sometimes those choices are made unconsciously versus consciously.
Now, we've talked about constitutional protections and federal enforcement of constitutional protections, but Ms. Ogletree-George, police can be prosecuted under state and local laws as well, correct? For unlawful uses of force?
Absolutely. Police can be prosecuted under state and local laws for unlawful uses of force. And in the recent few years, some states have uh, changed their laws regarding what kinds of force officers are permitted to use. And some have specifically incorporated de-escalation concepts into their state laws. So for example, California, Nevada, Maryland have modified their state laws to require that officers consider de-escalation. Some states now require that use of force can only be permitted when it's necessary, not just when it's reasonable. And so we are seeing some movement from states to more tightly restrict when officers are permitted to use force.
So we've talked about force, we've talked about the legal framework, but in the first instance, the frontline regulation comes through a police department's policies governing use of force. So T, can you just tell us generally, so what are the elements of a good use of force policy?
Sure, we look primarily at departments who have recently, and in the last 2, 3, 4 years or so, taken a look at what's happened in the policing environment and have amended their policies to really fit the more contemporary, what we call 21st century policing. And so in these agencies that have or are in the process of revising their policies, what we see in many of these agencies is a citation of core principles where the agency is adhering to core principles that include procedural justice, include de-escalation and community policing, core principles that include fair and bias-free policing. And so in many of these use of force policies, as a prelude to the policy language itself, we see the citation of these core principles and the expectation that every officer in the agency will adhere to these core principles. And these core principles actually become indoctrinated into the culture of these police organizations. So we see the core principles, and then we see the definitions of all things important and related to the use of force. And then we see policy language that mirrors at the minimum on the floor language prescribed in the U.S. Constitution, as well as the state and local laws. And the better practices today includes policies that have language with de-escalation requirements, as Ms. Ogletree-George indicated earlier, languages that really impose a necessity for the officers to use force only when it's reasonable, necessary, and proportionate to the threat, and not in any other situation or circumstances, and that officers and department members look to use force only as a last resort after efforts to de-escalate the situation have been engaged and unsuccessful in those instances where that's reasonable. We see officers required by department policy to embrace a use of force matrix where we understand that the force used will often be dictated by the level of resistance, and the force that is used is a response to the resistance encountered by the officer on that particular call. So these are all elements of good 21st century policing use of force policy. Ultimately, if the policy doesn't have language that clearly restricts certain officer conduct and situations and clearly require other officer conduct and situations, then the policies won't have the kind of restrictive and permissive language that is needed to construct meaningful training courses so that the officers can be trained on the policies themselves.
And earlier you described a wide range of kinds of force that can be used, forms of force and levels of force, forms of resistance. Would you expect a policy to address each of those and have a policy, well, for each of those levels of resistance, or what force can be used when?
Yes. Again, what we see in many agencies now is the application of a force matrix, and essentially, it will prescribe the appropriate level of force based on the amount of resistance that the officer experiences in his or her interaction with the member of the community. And so, lesser resistance will allow lower levels of force. Greater amounts of resistance will allow greater amounts of force. And the policy also is flexible enough to allow an officer to escalate whenever required. He or she doesn't necessarily have to go from level 1 to level 2 to level 3 to level 4, but in the appropriate instance, an escalation of force from level 1 to level 4 may be immediately required. And these policies are flexible enough, but yet instructive enough for an officer to understand what those situations are and the appropriate levels of force for those situations based on the threat that he or she perceives that actually exists, and that they're able to articulate in reporting what happened.
We often hear from people that police department use of force policies, or their policies generally, are really just designed to protect the officer or to protect the department from litigation. In your experience, well, have you seen that? And are there characteristics of policies that you think are more appropriate, or that there's a way policies should approach this issue that you think is more appropriate?
Again, I think Ms. Ogletree-George, because she's worked with so many different departments and looked at so many different department policies, may have a comment. But I tell you, the language included in the policy is important for the agency. The policy must prescribe certain conduct that's consistent with the Fourth Amendment. So the policy must prescribe the appropriate actions of the officer, but the policy also should have language requiring supervisory review. It should require reporting of those uses of force, and that it should require the department to periodically report out to the community what those uses of force are. Now, to the extent a department doesn't have the requisite language in the policy, if the policy isn't prescriptive enough, if it isn't written to the appropriate standard, then a department can be held legally responsible for failure to control the actions of their officers through the policy language, through the requisite policy language. So we want to see departments take the time to make sure that policies are carefully written, that they're written to, at the very least, a constitutional standard, and more preferably a 21st century policing standard. But there are also risks and liabilities if a police department today does not have a sufficient policy manual and sufficient training. They can, and in many cases, will be held civilly liable for the outcomes of a bad use of force situation.
Ms. Ogletree-George, you've surveyed many departments, consulted with many, worked for the Department of Justice. In terms of the range of different, well, let me pause for a minute. There's no one size fits all formula for even a best practices policy, right? That It's going to depend on the nature of the size of the police force, the community, things like that. Is that fair?
Right. It's fair. There is no one size fits all policy. You have to look at the particular department and the challenges they're facing and their practices. But I do think there are some standards that should apply for every department. It was the standard 10 or 15 years ago for every policy just to rely on the Graham standard, the objective reasonableness standard. I think that has shifted over time, and there are policies that do require that use of force must be necessary, proportional, and reasonable. And I do think that is a standard that should apply regardless of the size of the department or the particular characteristics of the department. I think that's the standard that it best serves to protect officers and protect members of the community. I think that shift in part is due to some of the work of the Department of Justice and pattern and practice investigations, where the Department of Justice would assess police departments to determine if there's a pattern of unlawful conduct, even though that authority has been in place since the 1990s. Particularly in the 2000s, there were quite a few investigations of police departments that ultimately resulted in findings of unlawful conduct and consent decrees or agreements between the city and the Department of Justice to move forward with reforms to policies and training and the systems in place to hold officers accountable. And I think through the consent decrees, there was a model for reform and for some of these policy changes to restrict uses of force beyond just the Graham standard. And so I think that was a beneficial change both for law enforcement and for the people who are in communities who are subject to law enforcement.
What are pattern and practice investigations?
Pattern and practice investigations are conducted by the Department of Justice. The Department of Justice Civil Rights Division has the authority to assess a police department to find out if there's a pattern of unlawful conduct. And that can mean a number of things. It could be a pattern of excessive force. It could be a pattern of unlawful stops or searches. It could be discriminatory policing or a pattern of racial profiling. And so there's a wide variety of conduct that could potentially violate the Constitution. The pattern or practice investigations are not intended to focus on a particular officer or a particular incident, even a high profile incident. The goal is to really look at the whole department and whether there is a sufficient information to show that something is happening on a fairly routine or regular basis. If there is a determination that there is a pattern of unlawful conduct, then the federal government has the authority to file suit, to sue the city, the police department. Often what happens is that instead of moving forward with litigation, the city and the Department of Justice reach an agreement. That agreement is typically a consent decree or a settlement agreement, but it really outlines all of the operations within a department that may come into play with the unlawful conduct. So it could be looking at training, it could be looking at supervision, it could be looking at accountability systems. If a department finds that an officer or a number of officers did use excessive force, what was the next step? What happened? Was it addressed by the department, or was that conduct swept under the rug? And so the consent decree really tries to cover each of those areas. Many of the consent decrees try to engage the community in the process and make sure that there are bodies set up in place and that the community is engaged with the police department, so that once the consent decree is over, there's still some connection between the police department and the community to make sure that those changes stay in place and that those reforms are permanent.
And as part of that reform process, the Department of Justice or an independent monitor charged with overseeing implementation of the consent decree will bring in subject matter experts to advise the department and guide it in terms of updating its policies and its practices. And in that respect, even though these are specific to a particular police agency, these new policies sort of set a new standard that other departments and other communities can look to assess their own departments' use of force policies and whether they're meeting the community's demands.
Yes, that's right. And the unique thing about consent decrees is that they're not a hidden agreement between the city and the Department of Justice. There's a federal judge overseeing the implementation of the consent decrees, and there's an independent monitor and subject matter experts making sure that the department is implementing the reforms.
And in talking about what makes for good policies, I noticed that the terms you all use, you use the phrase they instruct, they guide, they prescribe. So I'm going to ask either of you to sort of, in a nutshell, like describe, so what is the purpose of a good use of force policy, and how does it achieve that purpose?
Okay, I'll speak to that and then open the floor for my colleague here on the other end of this. The good policy establishes the parameters within which an officer or officers must operate in making use of force decisions, in reporting those uses of force and actually using force itself, reporting those uses of force, the department's review of the use of force, the standards for those uses of force review, and maybe even establishing how the outcomes of those reviews might be used to help reinforce better policy or reinforce training, how they might inform upcoming training, and so on and so forth. Consequences of use of force should also be identified in training, and especially if the force is determined to not be appropriate as prescribed in the department's guidelines. And so that force policy will represent the boundaries for the use of force, but then it'll be prescriptive, as we discussed earlier, in also identifying appropriate levels of force for the amount of resistance encountered by the police. And so we'll have some prescriptive nature within the policy, but more than anything else, the parameters around which and within which the officers and personnel must act in applying force to members of the community.
Ms. Ogletree-George, I'll ask you, in your words, what are the purposes of a good use of force policy, and how does a good use of force policy achieve that purpose?
As we discussed earlier, the Constitution and the Fourth Amendment sets the minimum floor for use of force, the bare minimum standard that officers need to meet. I think that the purpose of a use of force policy is to provide clearer guidance to officers on when force is permitted, when it's necessary. But I think at its heart, really, the focus is on the expectations of the community. Police officers always have to recognize that they have to be accountable to the communities that they serve. And so by setting a good policy that keeps that in mind and reminds officers of the sanctity of human life, and that the goal is to serve the community to their best ability, I think a policy helps draw clear lines about how a department can be successful in serving its community, and beyond just mandating sort of necessary and proportional force. A good policy includes all of those accountability systems to make sure that officers are following that policy, and that the department is paying attention, that supervisors are paying attention, and that officers are held accountable for violations of that policy.
Let me ask you this. You talked about transparency. If I wanted to find my police department's use of force policy, are those available to me? Do all departments make them available?
Many do. Not all departments make them available. It is information that should be available to someone through a freedom of information request or other access laws in the particular state where they live. But that should be an easy to access document, much more so than it was, 10 or 15 years ago.
You would certainly suggest it's a best practice for police departments to be transparent concerning their policies and post them on their website, or make it easy for people to know how they do what they do.
Absolutely. Police departments should post their policies. They should post data on stops, searches, arrests, uses of force. All of that is information that should be available to the public so they know what's happening in their communities.
You all have done a great job explaining the sort of basic elements of use of force policy and how they're put together. And it's a perfect background for what we'll discuss in our next segment, in which we'll actually look at some policies and really drill down into how police departments articulate their principles, their standards, and how they guide officers. But before we turn to that, Dr. Bowman, I'll ask you, I think it's worth just briefly touching on training, because policies are complex and just reading them, you're not going to be able to apply them in the world. Just talk about briefly the relationship between training and policies.
Sure. There is just an inextricable relationship between policies and training. Policies establish the parameters within which the conduct must occur. Then training reinforces the policies by giving the officers the text, the language, creating scenarios where they understand what might happen and how those policies might be applied out there on the streets, in their jobs, doing what they do. And so for any department, before you can put that accountability piece into place, you have to train on those policies. So you create the policies, you train on the policies, you make sure that the appropriate training models are used. Today, adult learning models are critically important in communicating policies through training to the rank and file in a police department. So the way the training is conducted is almost as important as the content of the training itself. But the training reinforces the policies. It ensures that that what happens on the street is congruent to what the policy says and to what the policy expects. And that training is the vehicle to make sure that what's happening in the real world is actually consistent with the language in the policy document itself.
And Ms. Ogletree-George, I'm going to give you the last question, but I'm going to come back to Dr. Bowman to give him the last word. So my last question to you is the role of culture. And if you could also, a role of culture in guiding use of force specifically, and the concept of a warrior culture versus the guardian culture that's discussed in these circles often.
Yes, I think it goes back to the point about serving communities and being accountable to communities. We ask officers to protect the people in the communities that they serve, instead of seeing the community as other or as an enemy or purely a law violator. And so the expectation is that we treat each other as human beings and protect each other. And so that is the ideal culture in a law enforcement officer and in a law enforcement agency, that they see the community that they're in as a resource, as a partner to solve problems with, as people worthy of protection. And the hope is that with the right leadership and the right policies and the right training and the right accountability, that many police departments can get there.
And in a future video, we'll be talking about the importance of the ability of the police to work collaboratively with the public, sort of partnership policing to promote public safety and to reduce crime. But that's for another day. But I appreciate that setup for that discussion that we will have in the future. But Dr. Bowman, I promised you the last word. So do you have some concluding thoughts to offer?
Sure. The other thing that we didn't quite touch on, but I think is really important, is to understand that police officers are human too. And sometimes, despite the policies, despite the training, police officers are not always 100% on their game. And so it becomes incumbent upon police officers to make sure that they are familiar with programs where they hold each other accountable, programs like ABLE, where they're willing to pat their fellow officer on the shoulder and say, "Hey, that's not an appropriate level of force. That's too much force to use. There are alternatives. Hey, why don't you take a break? I got this. Why don't you go over there and just chill out for a moment?" I think it's important that officers recognize the human side of policing, and that they're willing to step in and take charge in those situations when another officer may not be handling it appropriate. And thankfully, we do have programs now in the country that encourages that kind of behavior and conduct by officers. And that's part of this entire use of force equation as well. And then finally, officer wellness programs encourage that. So we have pieces in place that says every officer is not going to be 100% on their game every single day, every single call. But thankfully, we have safeguards and safety nets in place that will help make sure that the public can experience the optimal outcome, even when the officer isn't having the best day. So that's the only other thing that I wanted to mention today.
Well, that's a perfect thing and a perfect ending note, because it brings us back to where we started, because what you're really talking about are policing practices that are safe and effective for police and the communities they serve, which is our mission. So thank you both very much. This has been a tremendous session, and you've imparted a lot of insight and valuable information. So thank you.